Some people are reluctant to consider offshore Cook Islands Trust for asset protection because they have an impression that these trusts are illegal or essentially are putting themselves in a worse position than they are now because they're getting into something that is going to cause more legal problems than solve. The answer is that the Cook Islands Trust is perfectly legal, provided you comply with certain U.S. laws, reporting laws, and there is nothing illegal about moving assets to an offshore trust to increase asset protection. Now, where does this concept of illegality, or the illegality that is out there and some people are concerned about? I think most of that pertains to tax evasion, because there are people who believe that offshore trusts are used primarily to evade U.S. income taxes. And yes, there are some people have contacted me over the years asking how they can use an offshore trust to not pay U.S. taxes. And the answer is you can't legally do that. So that the offshore trust provides no tax benefit, really. In fact, that the trust, for tax purposes, is what's called a grantor trust. That's a technical term. But what it means is that the trust income or losses are flowed through to you on your personal 1040. It's a flow-through entity, like an S corporation. So that if the trust earns $1 of income, then that dollar goes right to your 1040. The trust does not file a tax return. The trust does not give you any shelter from taxes. It's almost a non-existent entity for tax purposes. So, of course, it doesn't provide any legal tax protection because the trust as a taxpayer is considered you. It's just a flow-through. What we find is certain people believe that if they move businesses or income-producing assets to the trust, they don't have to report them on their U.S. tax returns. But as I said, it's the exact opposite. It is the trust income is directly reported on your return. So if you fail to do that, it is nothing different than hiding income or evading income by any other device. And of course, it's a criminal action. So the offshore trusts are not tax avoidance or evasion tools. They are asset protection tools. Moreover, the IRS and Congress is concerned about people using offshore trusts improperly, and they want to know about them, and they want to know about any financial accounts that are set up through the trust. And for that reason, IRS regulations and laws impose reporting requirements. Reporting requirements are forms that you file, your CPA files with the IRS, notifying the IRS that you have an offshore trust and or notifying the IRS that you have offshore financial accounts. You don't have to list the income, or you don't have to report income on these forms, but you have to report the existence of the accounts and the existence of the trust on a yearly basis. And it is very important that you do so, because the penalties for non-compliance and non-reporting are very high. Even though there's no tax effect, you're not evading taxes. It's just that failing to notify has very, very high penalties and consequences. So, if you pursue offshore trust for asset protection, please work with a CPA who is familiar with the reporting requirements for offshore trust and offshore accounts. If you tell your CPA about these offshore entities, and the CPA knows what he's doing, that the reporting is not complicated and is not expensive to report, It's just as long as it's done, you'll be in full compliance and there'll be no tax penalties. So in the end, an offshore trust is an asset protection tool or maybe an estate planning tool. It is not a tax tool. It has no tax benefit or tax detriment. But there is this trap of reporting, and there's a risk that if you don't comply with these rules, you will be penalized by the IRS. So just be aware, make sure your CPA is aware, and you won't have a problem.